May it please the court, my name is Qingyue Song, and I'm the defense counsel for the respondent James Peterson, who was recently arrested and charged with 5 counts of breaking and entering premise and committing an indicate offense, section 421 of the Criminal Code, and 32 counts of burglary, section 419 of the Criminal Code. With the promise of the court, I would like to request 6 minutes for rebuttal. Thank you. This is a case about the police violating of the respondent's fundamental rights while enforcing an arrest and the subsequent questioning. As I will explain later on, the police, while arresting James Peterson, failed to uphold his obligations to caution my client that any statement he provides may be used as evidence against him. Similarly, the police also failed to inform the suspect during the arrest and questioning that he could speak to a lawyer. For this reason, I ask Your Honor dismiss the case for the following reasons. The first one, there is a clear violation of 431 of the PPR Act by the police during the arrest and questioning of suspect. Secondly, there was a violation of Section 418 of the PPR Act as the police failed to inform the suspect of his rights to speak to a lawyer. Thirdly, as a matter of the public policy, law enforcement officers are encouraged to caution child offenders for the first of subsequent offenders with the objective of diverting them from the criminal justice system as stipulated in the Youth Justice Act. This option has not been explored by the arresting officers. With regard to the first point of Your Honor, person arrested by the police under suspicion of committing offenders have the right to remain silent during the questioning by the police. This is in the laws of Australia. It is a fundamental common law rule, which is also known as to the right of silence, Section 397 PPR Act. The idea behind this law is based on the premise that it is the Crown to prove any case beyond a reasonable doubt. For this reason, accused person must not be compelled or duped into incrimination themselves, as was the case when the suspect, James Peterson, was arrested. The law in Queensland also obligates police officers to ensure that they are possibly satisfied the suspect under the said warning as stipulated in Schedule 9 Regular 6.2 Police Powers and Responsibilities Regulation 2012, Queensland PPR Regulation. While questioning endangered people, such as Peterson, in this case, Schedule 9 Regular 25 requires the police are expected to pose questioning aiming at evaluating the suspect's understanding or level of education. In the event that there is a suspension or delay of question, police officers are to repeat the warning according to Schedule 9 Regular 26.4. Concerning the second point, Section 418 of PPR Act requires the police officers must also notify suspects arrest of indicting offense that they have a right to speak to an attorney and must provide the means to do that, which may be in form of telephone. As is evident from the facts surrounding of the arrest of Peterson, there was no mention of his rights to speak to a lawyer, neither did the arresting police officer facilitate his communicate by providing telephone director of a phone. Essentially, the police were not only uneasy in the manner in which they obtained a confession from the suspect, but they were also in direct contravention of the law. Finally, the general policy about child offenders is that children should be for not only the first offense, but also those committing later. Well, this largely depends on the circumstances surrounding the case of the servant of every offense committed. The general idea has been to divert such delinquents from deviant behavior or the criminal justice agencies. According, these cautions are supposed to be given with extremely impartiality and supposed to address unique circumstances surrounding each case in the most. Whenever necessary, law enforcement officers throughout Australia are required to submit a police reform form which essentially transfers the offending child to the proper agency. whose role will be to help the child overcome his ill manners ways. The police officer should encourage the kid to discuss his action with the agency to which he is referred. In the case of beaten, this option is still yet to be fully explored, although the police have made some effort to involve a kid welfare worker. The police have not shown any intention to refer the matter to the relevant social agency to reform the child. In conclusion, in the light of the fact that the police violate the suspect's Section 431 of the PPR and Section 418 of the PPR rights during the arrest and questioning and fail to explore other alternatives for the child offenders, I hereby request the court dismiss the case on account of violation of criminal procedures and laws. Thank you.